The wedding photographer caught the moment on camera without knowing what he was capturing. In the photograph, the one I have looked at more times than I can count since that day, my mother is standing at the edge of the reception venue's garden terrace with her phone pressed to her ear. Her body is turned slightly away from the guests. Her expression is focused in a way that is different from the focused expression of a mother at her daughter's wedding. Different from proud. Different from emotional. Focused in the specific way of someone conducting business. I am visible in the background of the photograph. In my wedding dress. Mid-laugh, turned toward my new husband, completely unaware of what my mother is doing 14 feet behind me. She was on the phone with her estate attorney. She was instructing him to revise her will. She was doing it on the afternoon of my wedding, during the cocktail hour, while I was laughing in a white dress in the garden she had chosen for the venue because she said the light was better there than anywhere she had ever seen. I did not know any of this when the photographer captured it. I did not know it for another 3 weeks, when a source I will describe in detail told me what had happened and why. What my mother did not know, what she could not have known, because I had not told her, because some information is too valuable to share before it has done its work, was that 6 weeks before my wedding, I had sat across from her attorney in his office and had a conversation she had not authorized and could not have anticipated. I had spoken to her attorney. And what he told me that afternoon had changed everything about the document she believed she was protecting. My name is Celestine Marchetti Obi. I am 36 years old. I am a contracts attorney at a mid-size firm in Charlotte, North Carolina. I specialize in commercial agreements, the kind of work that requires you to read every word of every document with the understanding that the word that matters most is usually the one that seems least significant until something goes wrong. I have been doing this for 9 years. I am good at it. I am good at it in the specific way that people are good at things that align with how their minds naturally work, which in my case means I have always been better than average at identifying the gap between what a document appears to say and what it actually obligates. This skill has served me well professionally. It served me differently, more personally, more consequentially, in the year before my wedding. I need to tell you about my mother before I tell you anything else, because my mother is the kind of person who requires introduction. She is not a villain. I want to say that clearly and early because the story I am about to tell could be read that way and that reading would be incomplete and unfair. She is a complicated woman who loves her children in a complicated way, and the complication has always had the same source. She believes that love and control are the same instrument, and she has spent 67 years deploying that instrument with a consistency that is, in its own way, impressive. Her name is Rosaria Marchetti. She was born in Calabria, came to the United States at 22, built a small but successful import business over 30 years, and raised 3 children, myself, my brother Dante, and my younger sister Fia, with the specific combination of fierce devotion and absolute expectation that I think can only be fully understood by the children of immigrant parents who built something from nothing and need their children to carry it forward in the precise way they have envisioned. Rosaria has opinions. About everything. About how I should wear my hair and what I should eat and where I should live and who I should marry. About what constitutes a good career and what constitutes a wasted one. About the correct way to make Sunday gravy, which is a subject on which she considers herself not only an expert but a sovereign authority and on which no counter-argument has ever been successfully entered in the history of our family. She had opinions about Marcus. Marcus Obi, my husband, is the son of a Nigerian economist and a Jamaican pediatric nurse. He is 38, a structural engineer, extraordinarily patient, and possessed of a warmth that my mother has described, in our early years, as pleasant enough and in more recent years as genuinely lovely, which for Rosaria is approximately equivalent to a standing ovation from anyone else. The evolution of her opinion of Marcus was slow and is ongoing and is not the subject of this story. The subject of this story is the will. My grandmother, my mother's mother, Nana Julia, passed away when I was 27. She left an estate that was modest in the way of women of her generation who lived carefully and spent less than they earned for 60 years, the house in Asheville where she had lived for 40 years, a savings account, some jewelry, a portfolio of conservative investments that had grown quietly and reliably over 3 decades. Combined value at the time of her passing, approximately $800,000, split equally between her 2 surviving children, my mother Rosaria and my uncle Paulo. Rosaria's inheritance was therefore approximately $400,000. She did not spend it. She invested it. In the 7 years since Nana Julia's death, through a combination of the original investments and additional contributions from her business, my mother's estate had grown to a figure that was, by the year of my wedding, significant. She had discussed it in general terms with me and Dante and FIA, not numbers, not specifics, but the general shape of her intentions. She said she wanted to leave something meaningful. She said she had worked too hard and come too far to have it dispersed carelessly. She had a will. We all knew this. She had had an estate attorney, a man named Gerald Sorrento, who had offices in Charlotte and who had worked with our family for 14 years, since the year after Nana Julia's death. What I did not know until 6 weeks before my wedding, was that my mother's will had a specific provision that she had never disclosed to any of us. A provision that had been sitting in that document, quietly, for 4 years, that would have had significant consequences for me specifically if it had taken effect without my knowledge. I found out because of FIA. My younger sister is 29, warm-hearted, constitutionally incapable of maintaining a secret for more than 48 hours, and the person in our family who always knows everything before anyone else because she pays attention to things the rest of us overlook. She has always had a particular talent for overhearing conversations that were not intended for her, which she does not do maliciously but simply because she is present and alert in a way that her surroundings tend to underestimate. FIA called me on a Tuesday evening in October, 8 weeks before my wedding. She said, "Sully, I have to tell you something and I don't know if I should but I think I have to." I said, "Tell me." She said, "I overheard Mom on the phone with Gerald Sorrento last week. She didn't know I was in the house. I came in through the back and she was in the study. I waited." FIA said, "She was telling him she wanted to add a condition to your portion of her will. She said she wanted your inheritance to be contingent on your marriage producing children within 5 years of her death. And she said, Sully, I'm sorry, she said if you married Marcus she wanted the condition to require that at least one of the children be raised in the Catholic faith." I sat with that for a long moment. I said, "She said this to Gerald Sorrento?" FIA said, "Yes." I said, "And Gerald didn't push back?" FIA said, "I don't know. I only heard one side. But she sounded confident about it." I thanked FIA. I told her she had done the right thing by telling me. I told her not to mention this conversation to anyone, including our mother, and she agreed with the sincerity of someone who understood the weight of what she had just handed me. Then I called my own attorney. Not Gerald Sorrento, my own attorney, a woman named Patricia Gaines who was a colleague at a firm I had worked with before joining my current one, who specialized in estate planning and who I had worked alongside on several commercial matters involving estate components. I told her what FIA had told me. I described the provision as best as I understood it. I asked her to walk me through the legal landscape. She did. The provision as described, conditional inheritance based on reproduction and religious upbringing, was not unprecedented but was of contested enforceability under North Carolina law, particularly the religious component, which implicated constitutional considerations around freedom of religious practice. The reproductive condition was more complex. Courts had taken varying positions on conditions that regulated personal life choices as conditions of inheritance. Patricia's assessment was that a legal challenge would have reasonable grounds but would be costly, time-consuming, and emotionally devastating, particularly given that it would require challenging my mother's will after her death, at a moment when I would simultaneously be grieving. She said, "The stronger position is always to address something like this before it becomes operative. Before she passes. Before the will is probated. When there's still the possibility of conversation or restructuring." I said, "What does addressing it look like?" She said, "It depends on what you want. If you want to understand the full document, there's a pathway. If you want to explore whether the provisions are as FIA described them, there's a pathway for that too." I thought about it for 2 days. Then I called Gerald Sorrento's office. I did not call as my mother's daughter asking for information about my mother's estate, which would have been both unethical and professionally inappropriate. I called as a contracts attorney who wanted to schedule a consultation on a personal estate planning matter, which was true. I had been meaning to update my own estate documents since Marcus and I had gotten engaged and had simply not prioritized it. Gerald's office scheduled me for the following Thursday. I want to be precise about what happened in that meeting and what did not happen, because the line matters. I did not ask Gerald to disclose my mother's will to me. He could not have done so legally. Attorney-client privilege protects his client's communications and documents regardless of the family relationship between his client and the person sitting across from him. What I did was consult with Gerald about my own estate planning while being a contracts attorney in a conversation with another attorney about documents and their legal implications. And in the course of that conversation, conducted between two legal professionals discussing estate planning in general terms, I was able to establish several things that were important. First, I asked Gerald, in the context of discussing conditional inheritance provisions generally, whether he had ever encountered provisions conditioning inheritance on personal life choices, reproduction, religious practice, and what his experience was of their enforceability in North Carolina courts. He was thoughtful and thorough in his response, as attorneys are when asked professional questions by other attorneys. He described the legal landscape accurately. He noted that such provisions existed but that their enforceability was genuinely contested and that any sophisticated estate planning attorney would advise a client considering such provisions to understand that they carried meaningful litigation risk. Second, I asked whether, in his experience, clients who included such provisions in their wills typically communicated those conditions to the affected beneficiaries in advance or whether they were typically discovered at probate. He said it varied. He said, in his professional opinion, that provisions which affected beneficiaries' behavior or life choices were generally more ethically sound when communicated in advance, that a condition a beneficiary did not know about could not function as intended, since the behavior the condition was designed to incentivize or require would be occurring without knowledge of the consequence. He said, in my view, the most defensible and humane approach is transparency. If a grantor wants a beneficiary to do something in exchange for an inheritance, the beneficiary deserves to know. I noted this. Third, I asked about the process for modifying a will once executed, specifically, how a grantor would go about revising provisions after circumstances changed. He walked me through the process. A codicil or a new will. The process of revocation. The documentation required. The timeline. I thanked him. I paid for the consultation. I left. In the car outside Gerald Sorrento's office, I sat for a long moment. I had not learned the specific contents of my mother's will. Gerald had not disclosed anything he was not permitted to disclose. What I had learned was the legal landscape of the provisions FIA had described, their enforceability, their ethical weight as articulated by the very attorney who had drafted them, and the mechanism by which they could be modified. I had also, in the simple act of sitting across from my mother's attorney for an hour in a professional capacity, established a relationship and a presence in that office that had not existed before. I went home and I told Marcus what FIA had told me and what I had done about it. Marcus listened without interrupting. When I finished, he was quiet for a moment. Then he said, "What do you want to do?" I said, "I want to talk to my mother." He said, "When?" I said, "Not yet. I need to think about how." I spent the following 2 weeks thinking about how. Because how mattered as much as what if, maybe more. My mother is not a woman who responds well to confrontation. She is a woman who responds to being understood, which is a different and more demanding thing. If I confronted her with what FIA had told me, she would become defensive and the conversation would become about the leak rather than the substance. If I confronted her with what I had learned from Gerald's office, she would feel surveilled and the conversation would become about the ethics of my visit. I needed her to come to the conversation herself. Which meant I needed to create conditions in which that was the natural outcome. The conditions I created were simple. I told my mother, for weeks before the wedding, that I had been doing some estate planning of my own in anticipation of the marriage and had been thinking about what I wanted for Marcus and for any children we might eventually have. I told her I had found the process clarifying, that sitting with an attorney and building the document made the abstract feel concrete and had given me a new appreciation for the specificity required. I said, "It made me think about your will, actually." About whether what you've built for us is structured the way you actually want it. My mother looked at me with the expression she wears when she is trying to determine if I am saying the thing I appear to be saying or another thing entirely. She said, "My will is fine. Gerald takes care of it." I said, "I know. I just mean, I went through the process of thinking about conditions and contingencies, and it made me realize how important it is to communicate those things to the people they affect. I think if I were leaving something to someone with specific expectations attached, I would want them to know in advance. Otherwise, the condition doesn't serve its purpose." A pause. My mother said, "What are you talking about, Celestine?" I said, "I'm talking about estate planning generally, Mama. I'm just saying transparency seems important." Another pause. Longer. She said, "I'll call Gerald." She called Gerald. I do not know what was said in that conversation. I was not there. I did not have any way of knowing its contents. What I know is that 2 weeks later, 1 week before the wedding, my mother called me and asked if I could come for dinner on Sunday. Just the two of us. I went. We sat at her kitchen table with the gravy she makes on Sundays, the one that has been the same recipe for 40 years, and she was quiet for longer than she is usually quiet before she said something that I will not reproduce here word for word because it belongs to a conversation between my mother and me that I want to keep partly private. What I will tell you is the substance. She said she had been thinking about certain provisions in her will. She said she had revisited them with Gerald and had decided they were not consistent with what she actually wanted, which was for her children to be provided for, not controlled. She said she thought she had been trying to use the document to manage something she was worried about and that using a will to manage worry was not fair to the people the will was for. She did not name the provisions. I did not ask her to. I said, "I think that's right, Mama." She said, "I changed it." I said, "Okay." She said, "I want you to know I'm sorry for whatever I was trying to do." I said, "I know, Mama." She reached across the table and squeezed my hand and we ate the gravy and talked about the wedding and she cried a little when she described the dress she had chosen and I told her she was going to be the most beautiful person there except me and she laughed the way she laughs, when she is fully herself rather than managing something and we were okay. We were more than okay. I did not tell her about Gerald Sorrento's office. I did not tell her about what FIA had overheard. I did not tell her that the conditions she had decided to remove had been described to me 8 weeks before she decided to remove them. She changed her will. She told me she had changed it. The evening ended warmly. That should have been the end of the story. Except that it was not. The wedding was on a Saturday in December. The venue my mother had chosen had a garden terrace that caught the afternoon light in the way she had described, and she was right, the light was extraordinary, the kind that makes everything look slightly more real than real, the way important days sometimes feel while you are inside them. 220 guests. Dante walked me down the aisle because our father had been gone for 12 years and Dante was the next best version of that. Marcus cried. I did not expect him to cry and the unexpectedness of it made me cry, which Marcus had also not expected, and we were both crying at the altar for about 45 seconds while the officiant waited with the patient amusement of someone who has seen this before and finds it charming every time. My mother sat in the front row and watched all of it with an expression I had never seen on her face before. Not pride exactly, something more specific than pride. Something that looked like recognition. Like she was seeing something she had not seen before and was deciding how to feel about it. She danced at the reception. This is notable because my mother does not dance. She danced with Dante, briefly and badly, and then with Marcus, less briefly and considerably better, and at one point she was laughing at something Marcus said in the specific way she laughs when she has decided someone is genuinely funny rather than performing funny, which is the highest social endorsement available in Rosaria Marchetti's register. It was a good wedding. It was one of the best days of my life. And somewhere in the middle of it, in the cocktail hour while I was laughing with Marcus in the garden, my mother was on the phone with Gerald Sorrento. I found out 3 weeks later. The source was Gerald himself. He called my office on a Tuesday morning, which I had not expected and which produced in me, when his name appeared on my phone screen, a specific alertness that I think only another attorney would fully understand. The alertness of someone who knows that attorneys do not make unsolicited calls without a reason and that the reason is almost always significant. He identified himself. He said he hoped the call was not inappropriate. He said he wanted to speak to me not about my mother's estate, which he could not discuss with me, but about a professional matter that had arisen in connection with his representation. I said, "Go ahead." He said, "I want to be transparent with you about something that occurred on the day of your wedding, because I think you have a right to know it happened and I think you would want to know." He told me that my mother had called him on the afternoon of my wedding and had instructed him to reinstate provisions she had removed from her will at his office the previous week. She had said that she had reflected on the revisions and wanted to restore the original terms. He said, "I told her I would need to see her in person to execute any changes. I told her I could not accept verbal instructions alone for a document modification of that significance. I told her we would need to schedule a meeting." I said, "And did she schedule one?" He said, "She called my office 3 times over the following week. I was traveling. When I returned, she called once more. I asked her to come in." I said, "Did she?" He was quiet for a moment. He said, "She came in. We sat down. I walked her through the original provisions again, not the revised ones, the original ones. I told her what I had told her before, that provisions conditioning inheritance on personal life choices carry meaningful enforceability questions and that the more defensible approach was transparency with the affected beneficiary." I said, "And?" He said, "She asked me if I thought she should call you." I said, "What did you tell her?" He said, "I told her that was not my determination to make. I told her it was her estate and her relationship and her decision. But I told her that in my experience, documents designed to shape behavior work only when the person whose behavior is being shaped knows about them." I said, "Did she call me?" He said, "I don't believe so. Based on our last conversation, which was 10 days ago, she had decided not to reinstate the provisions. She left my office without executing any changes." I sat with that. The wedding photograph. My mother on the terrace with her phone pressed to her ear. The focused expression that was different from proud. She had tried to undo what she had done. And then she had gone back to Gerald's office. And then she had decided not to. I said, "Gerald, why are you telling me this?" He was quiet for a moment. He said, "Because you sat in my office 6 weeks before your wedding and asked me questions that told me you already knew something was wrong. And because you asked me, in the context of a professional consultation, whether I thought transparency was important when conditions affected a beneficiary's life choices. And I gave you my honest answer. And I believe, that answer was part of what led to the conversation your mother had with me before the wedding, and I want you to know that conversation happened and that the outcome was what it was." He said, "I'm not disclosing privileged information. I'm telling you that a process occurred and that it concluded in a particular way and that I thought you deserved to know that." I said, "Thank you, Gerald." He said, "Congratulations on your wedding. Mr. Obi seems like a good man." I said, "He is the best man I know." We ended the call. I sat in my office for a long time after. I thought about FIA calling me on a Tuesday evening in October. I thought about Patricia Gaines explaining the enforceability landscape. I thought about sitting across from Gerald Sorrento in a professional consultation and asking questions about transparency in the careful language of one attorney speaking to another. I thought about Sunday dinner with my mother and the gravy that has been the same recipe for 40 years and her hand across the table and the way she had said I changed it. I thought about the wedding photograph. My mother in the garden with her phone. She had tried to take back what she had given. And then she had gone to Gerald's office. And then she had chosen not to. I cannot tell you with certainty why she made that final choice. I can tell you what I believe, which is that Gerald said something in that meeting that mattered to her in the specific way that things matter to Rosaria Marchetti when they come from a source she respects speaking in a language she understands. Gerald had told her, in his professional capacity, that conditions a beneficiary did not know about could not function as intended. He had told her that transparency was the more defensible and more humane approach. He had been telling her this, apparently, for some time. She had finally heard it. Not because I confronted her. Not because I exposed what FIA had told me or what I had learned from his office. But because I had created conditions, first with the estate planning conversation, then with the Sunday dinner, then through Gerald's professional consistency in saying the same thing every time she came to him, in which the right choice became more visible to her than the other choice. I am a contracts attorney. I know that the strongest agreements are not the ones enforced by courts. They are the ones both parties actually want to honor because the terms are fair and the relationship is sound. I spent 9 years learning this professionally. I spent 1 year before my wedding learning it in the most personal way I can imagine. My mother has opinions. She always will. She will have opinions about how I raise my children and where we spend the holidays and whether Marcus's mother's jerk chicken recipe is as good as she thinks it is, which it is, but that is an argument for another Sunday. What she does not have, what she chose, finally, not to have, is a document designed to control what she could not control and to punish what she was afraid of. She has a will that says what it says without conditions. And I have a marriage to a man she now describes as genuinely lovely, which I have decided to accept as the full endorsement it is. That is the whole story. The part that is mine. The part that belongs to Gerald and to my mother and to whatever conversation happened in his office 10 days after my wedding is theirs, and I am content to let it remain so. The best legal work I ever did was not in a courtroom. It was in a consultation room, asking questions I already knew the shape of, with a document I had never seen and an attorney I had no right to ask directly. And in a kitchen, on a Sunday, talking about estate planning and transparency until my mother heard what she needed to hear. If you are carrying something you are afraid to confront directly, I want to tell you something I have learned from 9 years of reading contracts and 1 year of navigating my mother. The most effective approach is almost never the most direct one. It is the one that creates conditions for the other person to arrive at the truth themselves. That is harder. It is slower. It requires the patience of someone who can see the long game and trust the process. It is also, in my experience, the one that preserves the relationship at the end. My mother and I had Sunday gravy last week. She told me she had been thinking about updating her will again, not the conditions, just some structural things, and she wanted to know if I had any professional thoughts. I told her I would be happy to review whatever Gerald drafted. She said Gerald was very good. I said, yes. He is. We ate the gravy. It was, as it has always been, exactly right. If you have been navigating something with someone you love that feels too complicated to confront and too important to leave alone, this story was for you. The comments are open. I would love to hear where you are and what you are carrying.